Thank you very much. Well, I think therefore we can get underway, and we'll hear the submissions of Mr. Brannigan on behalf of the petitioner.
Thank you, my Lord. My Lord, as you're aware, I appear today on behalf of the claimant Oger Dubai LLC. My learned friend, Mr. Allison QC, appears on behalf of the defendant, Daman Real Estate Capital Partners Limited. There are, in fact, a petition and a set of applications before you today. On behalf of the claimant, there's a petition which you have before you for various orders in relation to the winding up of the defendant. On behalf of the defendant, there is a series of applications that were made, I believe, last week, which seek a stay of everything. And so it's probably important your Lordship understands that in addition to this petition, we have of course been seeking to enforce the award in this jurisdiction. And what the defendant is attempting to do, whilst at the same time arguing before you today that we have other remedies available to us that are better than winding up, is to take out an application to stay the enforcement of the award in toto in order to frustrate any attempts by us to exercise any enforcement we may wish to make in relation to the judgment of this court. It is probably sensible, my Lord, in accordance with I think your Lordship's what your Lordship anticipates, that I deal first of all with the petition and let my learned friend make his submissions primarily then in relation to his applications for a stay. I will of course be referring, whilst making the petition, to the applications they have made for a stay, because we say it is both notable and illustrative of the true background to this case and what in fact is happening.
Yes, well, I would be quite content for you, as you make your submissions, to deal with any points which are made in the skeleton argument by your opponent as you go along. Although, of course, you will have a freestanding right to respond to his applications when he makes them.
Well, I'm very grateful. That's very helpful, my Lord. Thank you for that.
Now, would you please bear in mind that I have had a chance to look at these papers in some depth. I know the background, I know the series of proceedings that have been before the courts. So you needn't labour too heavily on the chronology.
Well, that's extremely helpful. Thank you very much for that. That gets rid of the first page of my notes, if nothing else. Having seen the chronology then, the one point which I would pick up on as a point I was going to emphasise as I went through is simply this. As we'll come to in a moment, one, if not the key issue, which is going to be before you today, is the quite interesting issue of how the intersection of this jurisdiction with the Dubai mainland jurisdiction works in this situation. That is because, as we'll come to in a second, whilst the other side have a variety of points in opposition to the petition, you may feel that their real point is that intersection, what happens at that point of intersection. So the point I was going to emphasise as we went through the chronology is simply this. This court has already looked at and made a decision about that intersection. At the point whenever the learned Mr. Justice Steele had to consider whether or not he recognised this award in the DIFC, all of the arguments, and indeed some further arguments piled on top, were before him and pressed upon him by Mr. Paul McGrath QC, who was at that point representing Daman. Over a 2-day hearing, all the points which are now before the Dubai mainland courts, and which are said to be good points, were rehearsed in some detail before the learned judge, and the learned judge decided how this court should deal with the concept of recognising this judgment and treating it as a decision of this court in this jurisdiction. Its decision was one which the DIFC rules, and indeed the case law which is built up around this, expressly recognised. That being the ability of this court to recognise an award and to effectively then treat an award as a judgment of this court in this jurisdiction on particular conditions. Those particular conditions, as my Lord you will have picked up, being the provision of security for the award in this jurisdiction. That was not done. As a result, the award was, as at after the 29th of December of last year, recognised in this jurisdiction and recognised in effect as a judgment of this jurisdiction. And so the question of how this jurisdiction intersects with the Dubai mainland jurisdiction has been decided by this court. The question of whether or not we have a judgment of the court in this jurisdiction has been decided.
But what has not been decided is what species of execution should be available to you to give effect to the recognition of the award, to give effect to the judgment of the court.
That has not been decided in terms. And so what you are left with, and in a way let's jump to the meat of it, my Lord, what you are left with is a slightly unusual position, but one to which we say there is a really quite clear answer. Of in this jurisdiction, there is no challenge left to the award or to the judgment of this court. I say that because there has been, as you will have picked up, numerous challenges. The decision of the learned judge, Mr. Justice Steele, was appealed. That appeal was considered and dismissed.
Well, there was an application for you for leave to appeal. Was there a full appeal to the Court of Appeal?
No, the application for leave to appeal was dismissed.
That's right.
Sorry, I should have made that more clear.
Well, that was Judge Omar.
That's right.
I think. Were reasons given for his decision not to grant permission to appeal? I've seen reference in the skeleton arguments to his order.
My recollection, and I hesitate, of course I don't want to say anything that's wrong, my recollection is there were reasons, but they were very limited. There was, as you might get from the Court of Appeal, in the English jurisdiction, a couple of paragraphs. And my recollection, maybe Mr. Allison knows better.
My Lord, if I
Yes.
it says the basic premise of the reason why permission was refused is that by the time at which the decision was rendered by Judge Omar, the Dubai Court of First Instance had said, we are not going to hear the jurisdiction challenge to the award. And that was what was relied on by Judge Omar, rather than any other grounds. And that is why, as my Lord will have seen, an application for a reconsideration of that decision was filed by Daman.
I wonder if is Mr. Allison saying that that's the sole reason put forward by the learned judge? That's not my recollection.
I'm informed that's the principal reason. I don't believe the reasons are actually, unfortunately, in the bundle that's being prepared.
I don't recall that as the sole reason, but
Well, I wonder if I could ask the associate sitting in the Dubai court if she could ask someone in the registry to email to me the reasons that Judge Omar gave for his decision.
I've just sent that to you by email. It was an order of the 22nd of February, 2016. I've just emailed that to you, sir.
Oh, thank you very much. Thank you very much. But your recollection is that at least one of the principal matters that Judge Omar had in mind was the decision of the Dubai Court of First Instance that it had no jurisdiction.
My Lord, that's my instructions. The hearing before Judge Omer took place before
Yes.
the Dubai Court of First Instance
Yes.
had said we don't have jurisdiction,
Yes.
but Judge Omer's decision was rendered after that.
Yes, just get a pause for a moment, please.
My recollection.
Wait a minute, please.
Sorry, my apologies.
Yes.
My recollection is that may have been one of the reasons, but I'm not confident it
Well,
was
we'll-
expressed in.
No, I'm not suggesting otherwise.
Well, we'll see at some appropriate time. Yes, do go on. Could I ask? I'm so sorry. I just want to get this absolutely straight. Now, the application made to Judge Omer was an application made to a single judge of the Court of Appeal. Is that correct?
Yes.
My Lord, that's my understanding, yes.
And you either can ask the very judge who makes the order you wish to appeal from for permission to appeal, or if you do not do that, then you make your application to the Court of Appeal.
And it's the latter which happened in
And
this.
it's the latter that happened here. And if you are dissatisfied with the decision of the single judge, you can ask for a rehearing. Now, is that a rehearing before the full court, or is that a rehearing simply by another single judge of the Court of Appeal?
I haven't looked up the DIFC rules with that in mind. No doubt the other side considered it whenever they were turned down.
Well, we might get some assistance from our learned associate who knows these things better than anybody.
According to the rules, and in Part 44 of the rules of the DIFC courts, it can be before the same judge, but it's usually one judge that hears the reconsideration of permission to appeal.
Thank you very much indeed.
For your reference, it's Rule 44.15 of the rules of the DIFC.
44. And can you tell us, has that application for a reconsideration been assigned to a different judge than Judge Omar, or has it been assigned to him? Where is it in the works?
It has been assigned to a different judge, but as far as I'm concerned, there's no decision as of yet.
Right. Thank you very much. Yes, Mr. Brannigan.
One can, of course, make any number of applications for a reconsideration.
Well, only one. Once there's been a reconsideration, if the first judge declines to grant leave, and there's a reconsideration, and on that reconsideration that decision is upheld or not departed from, that's an end.
If the other side concede that is the case, that will be an end to it, then we're
Well, I
agreed.
can't see, certainly in terms of an appeal from the decision of Justice Steele, it seems to me to be plain that that's an end to it. Otherwise, it would just go on endlessly. It can't be right.
But it may be worth pausing to make sure the other side agree.
Well,
that
they can let me know what their position is when they come to address me. But I would be most surprised if you can have another bite of that cherry.
I'm not an advocate that throws brickbats in necessarily, but given that we've got another application before you to have another go at a stay, whenever
We'll come to that.
it does cause me some concern. So, dealing with that head on, we say that is no good reason in this jurisdiction to say that there's a genuine dispute in this jurisdiction about this debt. Mr. Justice Steele has made his decision. He has made it in clear terms. The other side were given their option as to whether or not they wished to put in security, and they chose not to. They appealed it. They lost on the appeal.
Yes. Well, they lost on their application to appeal.
Sorry, well, that's really what I mean.
Yeah, of course it is.
They lost on their application to appeal, and we say that the fact they've applied for a reconsideration doesn't assist. Which means that the real question is, what one does about the fact that they still in the Dubai mainland, if I adopt some of the phraseology,
Yes.
whether in the Dubai mainland that makes a difference. And we say it doesn't. And we say it doesn't because whilst I don't dispute that my learned friend's recitation of the cases show that where there is a genuine dispute within a jurisdiction about a judgment debt, about a debt, the petition should not be granted. Here we have a completely different situation. Within this jurisdiction, there is a judgment of the court for which there has been an application for permission to appeal which has been refused, and which is therefore an extant binding decision of the court. And we say that that is a significant difference than any other range of possible scenarios where you're not talking about a judgment of the court, you were talking about something where there hasn't been a judgment of the court,
Yes.
but you wish to dispute about another jurisdiction. Let me pick another example. One can stretch the examples, of course, to absurdity. But let's say, and I say this simply because Mr. Allison and I are in a case together involving Rwanda. Let's say that the other side had commenced proceedings in Rwanda, suggesting that within that jurisdiction they wished an order saying that the underlying arbitration award should not be honoured. Well, this court, one would thought, would shake its head and say, well, how on earth does that help you? Just because you are disputing this in another jurisdiction.
Yes, the Dubai mainland is the seat of the arbitration. The parties have agreed, by virtue of the arbitration clause, that the supervisory court for that arbitration would be the court of the Dubai mainland.
I absolutely agree. And that's why I start with my example, which is out here, and say, so the mere fact that you commence proceedings elsewhere trying to invalidate a decision doesn't help you. So the next question is, well, what if you have commenced, as they had at the time Mr. Justice Steele considered this, what if you have commenced proceedings in the supervisory jurisdiction? What happens then? To which the answer is that this court has looked at that, and we say has decided it, and I guess it has not absolutely addressed the question of precisely which method of enforcing the judgment should be used.
Yeah.
But what it has done in terms is say to the other side, right, we will take into account and deal appropriately with the intersection between the two different jurisdictions, as you, the defendant, have asked us to. And this is, I'll come to what the this is in a second, this is how we appropriately deal with it. We're not going to adjourn a judgment in this court indefinitely. We're going to adjourn judgment in this court for a specified period of time to allow something to happen. If you don't do it, then it will be a judgment of this court. The difficulty which one has if you adopt the proposition that the other side would have is that you end up very significantly undermining Mr. Justice Steele's decision. You end up undermining it because one of the key and most important tools of a judgment, i.e. giving you the ability to wind up a consultant company that refuses to pay its debts, is simply taken away if you can say that any extant proceedings on the Dubai mainland are sufficient to mean that you cannot apply in the normal way in this jurisdiction for a winding up of a company that is not paying a judgment debt.
But let me ask you this. Suppose you were not seeking a winding up, but you were seeking charging orders over these properties.
Yes.
With a view to their sale.
Yes.
The proceeds of which would go to satisfy the judgment.
Yes.
If a charging order were granted and you received the proceeds, but then the Dubai mainland court were to decide it did have jurisdiction and that the tribunal did not have jurisdiction, that the relevant provision is not to be construed as having retroactive effect.
Yes.
Do you accept that the respondent would have a right of recovery against you for the proceeds which you have received through this execution process?
No, I don't. I don't, because it's that precise, or that is at least one of the sub-questions which is answered by this court, deciding as it did back in December that this should be treated as a judgment of this court. In this court, we have an absolute right to go ahead and enforce that judgment.
And so the...
I have a secondary answer to that, but
Yes,
well,
right, yes,
I'm wrong
yes.
about that.
Yeah, no, do.
If I'm wrong about that, then it doesn't matter for this reason. Let's say I'm wrong, and let's say your lordship takes the view, well, they must have a right to come back and come after to get the money back and these charges and so on. They don't lose that right. The other side don't lose that right if you grant the winding up petition sought, because of course...
No, at the moment I'm just concentrating on a money execution. I want to keep the winding up order separate just for a moment whilst we work this hypothesis through, if you don't mind.
Well, the point I was going to make, because I anticipate that where your lordship is going, is if I say, well, they do have a right to get it back, your lordship's then going to say, well, isn't that a concern then, if they have been wound up in the interim? I may be jumping far too far ahead.
It's one of the matters I have in mind.
Okay.
But just for the moment, if you'd be kind enough, just concentrate on the hypothesis I put.
Yes.
Cash is realised from the sale of the properties.
Yes.
And it's received and goes to partial satisfaction of the judgment.
Yes.
Then the Dubai mainland court says the tribunal never had jurisdiction at all, and this award is a nullity. Does the respondent have a right of recovery in the DIFC in respect of the proceeds that it's put towards satisfying the judgment?
My answer is no.
And you had a second answer.
My second answer depends on saying, but you don't have to worry too much about that whenever you come to consider the position that faces us now in terms of the bankruptcy, in terms of the liquidation, sorry.
Right, go on and give that second answer.
So the second answer is this. Let's say I'm wrong about all of that.
Yeah.
And let's say, in fact, that this company would have a right to come back against
Yes.
my company. Doesn't lose that right if they're wound up, because as we say in the skeleton, of course the effect of the winding up petition is that a trustee is going to step in order to deal with the affairs of this company. If that trustee takes the view that what is going on in the Dubai mainland isn't just a yet further attempt to kick the can down the road, and there is in fact sufficient merit in it to justify spending the money in pursuing it, and it managed to get it overturned in the Dubai mainland courts, and your lordship, and I'm wrong about what I say, then that trustee can come back after us in this jurisdiction to get the money back.
Yes.
And the reason I was keen to give that second answer was to point out that whilst my primary answer is no, they don't have a right, it doesn't really matter when it comes to today, because even if I'm wrong about that, they're not going to be prejudiced if their point is a good one.
Well, if the court were minded not to grant your petition, and in the face of that, your clients were to seek charging orders and realise proceeds from these properties. The respondent would remain the owner of the right to prosecute the appeal on the Dubai mainland.
Yes.
Wouldn't have reverted to a liquidator.
Yes.
And if that appeal were successful on the mainland, why do you say there would be no right of recovery in the DIFC from your clients in respect of the proceeds that they receive?
Because we have a judgment from the court saying we're entitled to those monies and that we're entitled to execute upon. I suppose that the methodology would have to be that having obtained, you'll understand that we say that we think it's extremely unlikely they'll obtain what they say they're going to obtain from the Dubai court, but having obtained from the Dubai court that, they would have to apply. If they apply for a rehearing in front of this court, and if this court were to grant a rehearing and to change the judgment, or to say, we did give judgment, we're now going to lift the judgment or reverse the judgment, in that situation, I would of course accept they would have the right to get the money back from
But that's
us.
not part of the hypothesis at the moment.
Barring that,
Yes.
the position you then get is that the Dubai court, which is its own jurisdiction, has said one thing, and this court has said, well, that's terribly interesting. But this is the judgment of the court in this jurisdiction.
Yeah.
And that's why I say they don't get the money back. The hypothesis it changes if you add in the extra bits of them coming back here and changing the judgment.
Yes. So you might have a situation, continuing with this hypothesis, that execution is permitted within the DIFC, for the moment short of a winding up. And there could be no right of recoupment within the DIFC if the Dubai mainland court were to say the tribunal had no jurisdiction. But it might be the case that the Dubai mainland court, on the back of its decision that the tribunal had no jurisdiction, granted a right of recoupment.
It might.
Which would then potentially be enforceable in the DIFC.
Potentially.
And the question would be, well, either that's a risk for your clients to take in seeking execution prior to a decision of the Dubai mainland court, or is it something that this court that today ought to take notice of in making its decision whether to permit you to have your petition or to have any form of execution?
Well, the answer is both, I think, in that, of course, this court should take note of it. It can't ignore that possible scenario. I wouldn't ask it to. But it must be a risk for us. And it must be a risk for us because the reality, and I don't want to make it as a jury point, but it's a reality that goes to the place of this court as an entity that serves a useful function. Sorry, the place of the jurisdiction really more than the court.
Yes. Yes.
As an entity that serves a useful function under the laws of the land has been set up. This jurisdiction has been set up as a particular zone which would enable international commerce to take place. It's quite separate from and in a different jurisdiction to the domestic laws of Dubai. If the consideration which your Lordship has just indicated were to be treated as either determinative or one that overwhelms the other considerations, you end up in a position where actually getting the judgment and getting things enforced, particularly arbitration awards in this jurisdiction, becomes all but meaningless. For precisely the reason your Lordship said, if in fact what the other side are doing is a way of simply putting an end to being able to enforce a judgment in this jurisdiction, if you can in any way get it into the Dubai court, one can use any metaphor you want. Well, cutting the legs out from under, running or coaching horses through. No doubt we could all have our favourite one that amount to the same thing, which is effectively saying, well, if in one jump one is free, well, what's the point? What is the point of doing it? And one would have presumed and thought, and I mean this, as I hope your Lordship appreciate, to me, with the greatest of respect to him and as a rhetorical question, one would have thought that the learned judge, Judge Steele, would not have gone to the trouble of actually granting enforcement in this and other cases, if in fact that coach of horses, one could hear the drum, the footbeats in the distance.
All right, now help me with this. These properties
Yes.
are not within the DIFC area.
No.
And so, if you were to obtain the equivalent of a charging order over the properties for their sale, how would you go about that? Would you have to get an order from the DIFC court, which is then sought to be enforced at the Dubai mainland court?
That's the whole point about winding them up. It's not as the other side would hint, because we're trying to put fear into them. The way one can properly go about this is to recognise that this company has chosen to register itself in the DIFC. It is therefore managed in legal theory in the DIFC. So the way to do this is to ask the court to exercise its supervisionary jurisdiction, this court to exercise, and this jurisdiction to exercise a supervisionary jurisdiction over that management.
But would the liquidator have to obtain orders from the Dubai mainland court in order to realise the assets which are within the mainland jurisdiction and not within the DIFC?
We don't think so. We think the liquidator can act as a liquidator, has overall control over this. The one, as I say that, the one problem we have with that, which may lead to more difficulties, is that we now know that for reasons that have never been properly explained, although this company, on the face of the legal record, show legal title to these properties, there are in fact various documents which have been signed which give beneficial title to various officers of the companies. I can see that liquidator may have to deal with that in the Dubai courts in order to resolve that issue as to whether or not in fact the company owns that, whether or not those transactions need to be opened up or not. The truth is I couldn't give you a definitive answer on that. We would hope that the liquidator can simply act from within the DIFC to do that. We would anticipate that officers of the company and those who own those properties or appear to own those properties by means of these signed letters given the beneficial ownership may take a different view. And one would anticipate they may apply in the Dubai court to have those sort of issues dealt with.
You see, cross-border insolvency, take a completely different case. There's an insolvency in the United States, and the insolvent company has assets in England.
Yes.
In order for those assets to be brought within the insolvent estate, the winding up, or whatever it's called in the United States, the order of the court had to be recognised within England and Wales, and then ancillary orders made to assist in the American winding up. And at the moment, I would imagine that something similar would have to happen in this case. Any bank accounts that are within the DIFC have negative balances, as I understand the evidence. So far as you're aware, there aren't any other assets in the DIFC. I've not looked carefully at the affidavit of assets.
As far as we're aware, that's the case.
So such assets as you're aware of and are deposed are in the Dubai mainland. And one way or another, you're going to have to obtain orders from the Dubai mainland to assist in the execution of those assets.
That's at least possible, and I think your lordship can work on the basis it must be a real possibility.
Right. And so there must be a prospect that when you come to seek to do that in the Dubai mainland, it will be opposed by them on the basis that there is a jurisdictional appeal pending within the mainland Dubai courts.
Well, no, but that's it. Is your lordship talking? Well, is your lordship talking about us seeking to get in those assets before the respondent is put into liquidation, or
No. Now I'm in a liquidation.
Oh, in a liquidation. But the difference is this: you say the respondent will oppose it. If in fact we have a liquidator in place, the liquidator will be able to take a view as to whether or not this particular, of course in the usual way, he'll have to act independently. The gentleman we have put forward as the suggested liquidator is well known in the jurisdiction, actually both in this jurisdiction and in the mainland Dubai jurisdiction. Yeah. So a well-known liquidator he hasn't been picked on the basis he's particularly friendly or unfriendly to either side. That liquidator will have to decide whether he wishes to maintain the position in the Dubai courts.
But where did he end up in court? Because he'll seek directions from the court. In order to protect his position. He's almost certainly going to do that, isn't he?
I don't know, is the truthful answer. None of us have spoken.
Well, that's what I would have expected. I mean, I would need some instruction, but that's what I would have expected. So I'm just wondering whether all roads, in fact, end up. Well, no, perhaps that's not correct. If he has to seek the directions from the court, it would be the DIFC court that would give him, that would hear that application.
And it would be him seeking the directions?
It would be him seeking the directions. Exactly. No, it wouldn't be the respondent, as you say. It would be him. He would take an independent view as to what's in the interest of the estate, and he would come to the court seeking directions, backing that independent view, and it would be the DIFC court that would make that decision.
And giving the court a transparent insight to what actually is going on with the assets of this particular company. And I say that against the following background. Your lordship may have picked up the more recently filed affidavit of the gentleman, one of the gentlemen who runs our company.
Where do I see that?
In tab 17, file page 725.
Yeah.
It's a witness statement of Mr. Galaini. Now, it's been filed in order to deal with some of the points that were made by the other side in terms of a stay.
Yes.
He points out a number of things. For instance, if you turn through to page 726 and look at paragraphs 2.2 through to 2.4.
I'll just look at those. Yes.
And having looked at that, you might just, because your lordship has had a chance to look at it, you might just want to read the remaining bits of paragraph 2 and just look at paragraph 3 briefly.
I have.
I'm very grateful.
I've read it.
So, the aim of us trying to get an insolvency practitioner, an independent insolvency practitioner to look at this company, isn't to put fear into the other side, but to ground in reality the fact that we feel that in a situation where this company is not paying a judgment to debt, and in a situation where we have tried our best to work out exactly what is going on with these companies' assets and come up short, and not come up short because of lack of effort or lack of asking, but because of a wall of silence every time we ask any question such as, Given we know you only have 15 million dirhams in your bank account, how have you paid 24 million dirhams out, for example?
Yeah.
We see it as being a significantly better position, even if we all end up, by all I mean us, whoever is running Daman, all end up in the Dubai court. We would far rather be against a liquidator, I should say, not trustee bank, sorry, a liquidator who's independent and who is actually being transparent with everybody as to what is going on with this company. And certainly it seems to us, as a creditor who is owed over 250 million US dollars, it would be infinitely preferable to have that liquidator come to this court, tell the court this is what is happening, this is what the actual true position is in relation to these assets, this is what I, the liquidator, would like to do about it. And the liquidator may well say to this court, I intend to apply for the following orders in relation to the following properties and against the following directors in the Dubai court. But that is a markedly different position from the position we currently find ourselves in, of if the other side succeed in what they're trying to do, the leg's been cut out from under the judgment we have in this court. No real ability to do anything about that apart from wait until the other side, as claimant in the Dubai court, run that to exhaustion.
Yeah.
And as a claimant, and I do not mean this pejoratively toward the Dubai court, it is just the nature of the beast, they will have all the chances in the world to run it to exhaustion over a period of years. That's the reality of it.
Yes, because at the moment the decision is founded on lack of jurisdiction within the court. If the appeal court, the mainland appeal court, decided there was jurisdiction, I don't know whether it has to go back to the first instance then to decide.
We believe it does. We believe that it doesn't work the same as a
go back
respondent
to
notice.
the appeal court to Dubai and then go to the UAE Supreme Court.
And the Court of Cassation and all steps in between. And with multiple, we presume, frankly. And we think the court can take account of how this has been conducted to date by the other side and the observations by Mr. Justice Steele whenever he looked at how they had been conducting themselves in the back court. We think that this court can take it as a real possibility that the other side will use every avenue for rehearing an appeal within the Dubai court system that's available to them. The reality, stepping away from this, my lord, and looking at it, if we can't do something in this course, we're looking at years worth of expenditure of millions and millions of dirhams against a background of, and here I will dip a little bit into jury speak, against a background of the three arbitrators who looked at this deciding that this company acted in bad faith, and having done so, having heard evidence from the relevant people within the company who denied that they had. And then Mr. Justice David Steele, looking over 2 days with the assistant Mr. McGrath on the other side and I at all the arguments the other side were deploying, and concluding that at least some of them dealt with dishonesty in them. And with,
In short, you say that a winding up is the only way of cutting this Gordian knot.
absolutely. And your lordship can observe, can again take this observation as an observation that's proper to take account of. We wouldn't be asking for the order for no reason. If we thought there was a way, we didn't have to be here today arguing about a winding up petition, because we recognise that it's a hurdle, it's a set of hurdles we have to jump over. We recognise that. If there was another way of doing it that would work, we would do the other way of doing it. We're doing this because this is the way to cut the Gordian knot, as your lordship has indicated, and because we ask rhetorically, surely the whole point of this jurisdiction, having jealously guarded its ability to enforce judgments for companies that have chosen to register in this jurisdiction, and this method of enforcement being one which is available to enforce judgments in this jurisdiction. And all of that against the background of precisely these issues being exactly the sort of issues that are going to arise time and time again in this arena. Because there are very few companies that operate within the DIFC that do not intersect in some way into the Dubai mainland. That's just the reality of it. This is the way to cut the Gordian knot. It doesn't open the floodgates to all companies, because you have to satisfy the jurisdictional requirements for this court to be able to give an order giving judgment to start with. But what it does mean is that those companies who wish to take advantage of the DIFC jurisdiction, either because they choose to register here or do business here, then have to live by the rules of that jurisdiction, which involve, in a situation such as this, where there is both opaqueness, lack of good faith, and the court has found dishonesty in the way the other side conduct themselves in terms of court proceedings, cutting the knot by having a liquidator, if a judgment is not paid, step in and say, I may take all the same points that Daman were going to make against you, but I'll only do so if the proper points to make. That's the whole point of that liquidator jurisdiction.
Yeah. Yes, thank you.
I should probably just deal, I suppose, with two of the points, because the other side make them. In addition to the point you and I have been discussing at some length, they also say that it would be oppressive and unjust for the order to be made. I think to some extent...
To some extent you've dealt with.
I've dealt with that. I simply point out this, and we point out the skeleton. It's hardly oppressive in a situation where, if their points are good ones in the Dubai court, and or in relation to the assets and our entitlement to get hold of them, and those are all points the liquidator will no doubt take. And the third point we've definitely dealt with, which is whether or not there are other alternative means of enforcement available to us, which are either better or sufficiently good to mean that we should not grant the petition today. I think we have canvassed that. It just isn't. For all the reasons which we've indicated, all the other methods of enforcement will end up in the Dubai court with a miasma of vagueness and refusal to give information to us. That's certainly what's happened so far, overlying the top of it. And we can only presume that points are going to continue to be taken by Daman, which are just thoroughly bad points, and which Mr. Justice David looked at previously and said were thoroughly bad points. All of which will simply serve to elongate this. One would hope that with the liquidator on board, the liquidator will take the view, my job as liquidator is not to kick the can down the road. My job as liquidator is to take the good points, eschew the bad points, and to solve this problem. So that's all I'd say about that. Yeah. I'm very grateful for your patience.
Thank you very much. Yes.
My Lord, thank you. Frankly, my Lord, what we have heard for the last 50 minutes shows the fundamental error in the claimant's case before your Lordship. They're shooting at the wrong target. They're not answering the right question, which my Lord posed at the outset, and they still didn't attempt to answer it. This is not a request for an enforcement of a judgment by way of a charging order. This is an application by the petitioner for the exercise of the class right of a winding up. The authorities are clear. That is not enforcement of a judgment debt. That was accepted by the petitioner at the injunction hearing before Justice Sir David Steele, indeed accepted it in their skeleton argument. The judge did not decide when granting recognition and enforcement of the award whether the petitioner should be allowed to rely on the award to find a winding up petition in circumstances where the award is subject to challenge in the Dubai courts. Now that's the only question for my Lord today in relation to their request for a winding up. It's materially different to the question that's asked by the court when deciding whether under the arbitration law, section 44 of the arbitration law, to recognise and enforce an award made by an arbitration tribunal. The question for my lord is there a dispute to the petition debt that is to be characterised as more than merely fanciful? And we say that unless the petitioners can satisfy my lord today that the dispute is one that is merely fanciful, they must fail on their winding up petition.
But just help me with this. Why hasn't the order of Justice Steele permitting enforcement if security is not provided in 4 months, why hasn't that in fact precluded any further reliance on the pendency of the challenge in the Dubai mainland courts?
My lord, because that is in relation to enforcement of an award. It's not in relation to a petition. Putting it another way, if we were in the courts in England, the authorities make clear and the textbooks make clear that if one has a judgment of a first instance court in England, that judgment is, of course, final, only subject to a successful appeal. Now, even in circumstances where a stay has been refused by the first instance court and the appellate court, you still can't go to court and get a winding up order in the interim if permission to appeal has been granted. Why can't you do that? You can't do that because the getting of permission to appeal shows that the prospects of success are more than merely fanciful.
But is the appeal you're referring to the appeal that is constituted by the application for reconsideration of Judge Omar's order, or if not, what is it?
My lord, that's one matter, but no, the matter that I'm fundamentally relying on today, and we can look at what Justice Sir David Steele said at the injunction hearing only a few weeks ago, where he reached a similar view on the authorities. We say the relevant question is, today, can the court say that our challenge to the jurisdiction of the DIAC tribunal, whose award ultimately found this petition debt, is a challenge which does not get above the bar of merely fanciful?
But that assumes that the way is open to you to make that submission. What's said against you is that it isn't open to you, that the court has decided, exercising its discretion, that the prospects of success on the jurisdiction appeal to the mainland court is so small, although just enough to constitute a decision that it is unarguable, that there will be enforcement unless you put up security. And at the moment I'm not understanding why that does not shut you out from praying in aid, dependency of the jurisdiction proceedings in the mainland court. Those were the very matters that the judge had to weigh in the balance in deciding whether to grant an order of enforcement. And we know what his decision was. Well, you can put up security, but then you can go off and make this argument. But if you can't, you can't.
My lord, absolutely. I make clear that I'm not addressing the question of whether they could get enforcement by way, for example, of a charging order. I'm addressing the question of the winding up petition and what is the relevant threshold before the court will take the draconian step.
What's the justification for splitting off an application from a winding up from an application for enforcement as a judgment?
The justification is as follows on the authorities that we'll look at, and indeed the reasoning of Justice Sir David Steele at the injunction hearing 2 weeks ago. The question the court has to ask, as found by the judge at the injunction hearing, the question the court has to ask in the context of a winding up petition is a different one. The question the court has to ask is is the prospect of challenge one which is more than merely fanciful? If it is, then one can't engage the class remedy of a winding up. You have to look at other remedies. And that is not a question that was answered at all in the context of the recognition and enforcement application. Indeed, it's a question that was only answered in the context of the injunction application, and there the judge was very clear in saying, in his view, the relevant test was, is there a more than merely fanciful prospect of succeeding? And if there is, then it's not a winding up case, and we'll look at the reasons the court gave. And that's what we say the question for my lord is today. Can they convince you today that the prospects of the challenge to the jurisdiction of the DAC tribunal are merely fanciful?
Well, the first step for you is to persuade me that it's open to you to run that argument. And I want to hear more from you on that. You're at a very early point in your submissions. I've interrupted you right at the beginning. That's the prerogative of the court to try and get at the heart of the matter. So you understand that one of my principal concerns is to decide whether any of this is open to you. And then if it is, then of course one will look at the authorities.
Putting it another way, what did the court decide at the hearing in December for recognition and enforcement of the award?
Yes.
The court decided that the award should be registered and treated as if it were a judgment given by this court. That is what it decided.
Yes.
Now, if there was a judgment of this court, let's not consider this case for a moment, let's consider a case in which there was a judgment of the DIFC court, or indeed a judgment of the English court.
Yes.
Now that judgment is enforceable, of course, unless there's any stay on execution. The normal rule is one wouldn't get a stay on execution pending an appeal. But what if there is a pending appeal to the appellate court against the decision of the first instance court? So outside the world of arbitration for a moment, a judgment of the court subject to an appeal. In those circumstances, what the authorities tell us, what the textbooks tell us, and what the judge decided at the injunction hearing only 4 weeks ago, in those circumstances, you cannot rely on your judgment to get a winding up order before the appellate court has considered the issue.
Well, I can understand that argument within the DIFC context, where we have Judge Omar refusing permission to appeal, but there is still an entitlement to a reconsideration. That's been assigned to a judge who told that is pending. That I can understand, all within the context of the DIFC. Your argument is larger than that. You're asking this court to have in mind the appeal from the first instance decision by the mainland court that there's no jurisdiction.
Absolutely. Absolutely. And the analogy that I was hoping to make a happy one for my lord, so my lord saw the way it worked, is assume we're not even in the enforcement of the arbitration award at all, because the recognition of an arbitration award in many respects is no more than treating that as if it were a judgment of this court. Yes. For all purposes.
Yes.
Now, if this had originally been a DIFC jurisdiction dispute, and if my lord had ruled at first instance that Daman should pay roughly the sum of $300 million US, and if my lord had refused a stay of execution pending the appeal of my lord's judgment, but the appellate court was going at some point in the future to consider an appeal against my lord's judgment, but the appellate court had also said no stay of execution pending an appeal, the result in those circumstances would still be that no winding up order could be obtained unless the judge sitting in the winding up court, and you're of course sitting here today with your winding up hat on, unless the judge sitting in the winding up court could be satisfied that there was no realistic prospect of that appeal being successful, that appeal was merely fanciful. Otherwise, my lord, sitting with the winding up part, is wrongly moving into the jurisdiction of the civil courts and the way that the parties have decided to have their disputes resolved amongst them.
Yes. Well, as I say, I can understand that argument within the context
of a unitary jurisdiction.
My Lord,
It does seem to me, more as a common lawyer than as a chancery lawyer, a very, very odd state of affairs, that one can take all the steps of execution where there is a pending appeal but no stay has been granted, except for a winding up.
My Lord, that is because...
Train is nuts.
My Lord, with respect, no, because the winding up is the exercise of a class remedy on behalf of all creditors, which is usually the death knell of the company. It is something which the courts have found, as recognised in the claimant's skeleton for the last hearing. A winding up petition is not a form of enforcement. The authorities are clear on that. It's a class remedy. It's not an enforcement. And in those circumstances, the way the winding up court sits is, we do not decide disputes. If there's a more than merely fanciful prospect of that dispute being established, we don't determine it. Giving my Lord another analogy, the winding up court has said that if there is an arbitration clause in a contract, even if the winding up court thinks the dispute is so much of a put-up job that it's not even fanciful, the winding up court will still not make a winding up order, because the parties have decided that their disputes will be subject to arbitration, and it is not the function of the winding up court, even if they think the challenge is absolutely hopeless, to itself rule on that.
Yes.
So whenever there is a sense of a dispute, the winding up court does not descend into the breach.
Right.
It leaves it to the correct forum to resolve
Yes.
those factual legal issues.
I follow that, but but the winding up court has to take a view as to the arguability of the appeal.
My Lord, accepted, and if the winding up court can determine that the appeal can be characterised as merely fanciful, then in those circumstances the winding up court on the authorities can go ahead. If, however, the winding up court cannot get to that very serious end point, the winding up court says, look, you must go and establish your claim in the appropriate forum.
Now, do I have in the bundle the skeleton argument put before Judge Omer in support of the application for permission to appeal?
My Lord, I don't believe you do. I wasn't instructed at that point. It's not in the
Well, I think
materials.
I ought to have that, because I'm concerned with the appeal within the jurisdiction and use of it, then I should also be very concerned with the appeal outside the jurisdiction. Now, I haven't got the we'll call them the pleadings that have been advanced in the Dubai mainland court. They probably will be in Arabic and have to be translated.
No, they are translated, but they're voluminous.
So they're very
My Lord simply has the Dubai Court of First Instance decision and the appeal that's been
See,
made.
if I were minded, and this is a matter that's entirely in the air at the moment, if I were minded to say, well, I must at the very least look at the prospects of success of an appeal against Mr. Justice Steele's order, I think I would need to see your skeleton argument put before Judge Omer. Now, can that be got to me very quickly?
Yes. Yeah, so I could email you that.
My Lord, I'm told those instructing me can.
Well, the email address is one word, rfield at oeclaw.co.uk.
Well, thank you. Those instructions are arranged for that to be done. But
Yes.
My Lord, my fire there will be focused predominantly on the Dubai courts
Yes.
and what the courts in the DIFC have already found at two separate hearings in relation to that, namely that it does overcome the hurdle of a realistic prospect of success, and my Lord sees that further from the reasoning of the DIAC tribunal on the jurisdiction ground, where they found the issue difficult, and that's the way Justice Sir David Steele characterised their consideration of the jurisdiction issue.
Well, it's my of course, I must take account of the views expressed as to the arguability of the jurisdictional question, but it essentially is for me to decide in this hearing.
Yes, absolutely. I absolutely recognise that, but I say, with respect, my Lord should do that against the landscape of statements that have been made previously by both the DIFC courts and the DIAC tribunal, and the fact that ultimately it's a matter for the interpretation of the UAE constitution and the laws of Dubai in relation to the effect of the DIAC rules.
Yeah.
Lord, can I help in this way? I don't normally like to interrupt, but wait for a moment. I don't think the other thing I don't think you have, or at least I couldn't find it in the papers, was the original judgment of Mr. Justice Steele whenever he granted the order back in December.
No,
That's enough.
You have that.
Well, we're going to go to that in the course of my
we've got
submissions.
that, and I've read that.
It's followed in this, sorry.
So that's the touchstone that we say is the relevant one for my Lord. Can my Lord be satisfied today that the prospects of that challenge to the award, which is the root of the petition debt in this case, is one which is merely fanciful alone? And we say if my Lord cannot do that, then the only conclusion on the authorities we will look at is the dismissal of the petition. And my Lord, as we point out in the skeleton, the question of the hurdle has already been considered before by the DIFC courts in two different contexts. One by Justice Sir David Steele in the context of the recognition and enforcement application, where he found that there was something that passed the realistic prospect of success threshold, but for other reasons he found that security should be ordered as a precondition of the company being able to resist the enforcement. And my Lord sees that the issue was revisited again at the hearing for an application for an injunction restraining advertisement of the petition, where similar observations were made. My Lord may also have had the opportunity, we referred to it in the skeleton argument, of seeing that the DIAC tribunal found the issue difficult. They rejected a large number of the arguments made by the petitioners in relation to why they should be said to have jurisdiction, and got there in the end by finding that the rules had retrospective effect. And my Lord will have seen that what Justice Sir David Steele did is characterise the DIAC tribunal as having found the issue difficult. So we say, in view of that state of affairs, the dispute is one which passes the threshold. This is therefore not the correct forum to resolve the dispute. We say the point is even more acute in the present case, where one has the important interrelationship between the jurisdictions of the Dubai courts and the DIFC courts. And we say that's another discretionary reason why in the present case my Lord should not be making a precipitous order in circumstances where there is a dispute which is currently pending before the courts of Dubai. My Lord would have seen collateral purpose and other remedies are also raised in the skeleton. I'll come to those in due course. But by way of introduction, the alternative solution we posit for my Lordship, if my Lord feels for whatever reason the petition should not be dismissed today, is an adjournment so as to enable the Dubai Appeal Court to rule. Now my Lord will have seen the only reason we currently haven't got a determination from the Dubai courts on the jurisdictional issue is what everyone, and by everyone I mean the parties and Justice Sir David Steele, found a rather surprising conclusion, which was the ruling of the Court of First Instance that they did not have jurisdiction in relation to the issue. And my Lord will have seen from the translation as we set out in the skeleton that the Court of First Instance appears on a reading of the reasons to have been under the misapprehension that because there had already been some sort of proceedings before the DIFC court, the recognition and enforcement proceedings, the ones they refer to, that the DIFC court was the review court and not the courts of Dubai. Now that came out of left field for everyone. Therefore there are proceedings before the Dubai Appeal Court which were initiated immediately to consider that. My Lord will have seen from the skeleton there's already been a hearing or hearings before the Dubai Appeal Court. I'm instructed that there have been 3 rounds of written submissions, the last set being today, and that we have been told as of today that the decision of the appeal court is anticipated on the 8th of June. That is what we've been told.
Well, what's the basis of that? Certainly, I accept that's what you've been told.
From the Dubai lawyers, from our.
And what have they got that allows them to? Has there been some notice from the court or what?
I'm not aware of any such notice, my lord.
Okay. My lord, if I can assist, that's further information provided yesterday and this morning by the Dubai lawyers, that they have been told by the Dubai Court of Appeal that that is the anticipated date.
They've been told by the court?
My lord, yes.
Have you yourself seen these go, this
My lord, no, I haven't. I've just seen the communications from Mr. Bideri setting out the context of the discussions with the Dubai lawyers.
8th of June? Yes.
And that's consistent with what we were told previously, which is it was anticipated that a ruling would be made within 4 weeks of the closing of written submissions, and my understanding is the last set of written submissions were filed today.
I see.
So, my lord, we say as the alternative an adjournment to allow the proper forum at least to rule on whether they are taking the jurisdiction issue would be the alternative way for my lord to proceed today, rather than making a draconian order in respect of.
Well, where would it end? Suppose the Dubai Appeal Court upholds the court of first instance, so there's no jurisdiction. There are further rights to appeal. Is there, I'm not sure, is there within the Dubai mainland a court of cassation before you get to the Supreme Court of the UAE?
My lord, I'm not certain on that.
I'm not certain as well. I believe there is, but I'm not certain.
Lord, I'm just going to ask my instructions. Solicitors are not being rude by typing, but getting
Yes,
over there.
But again, if I can assist my lord on that, and let's assume the unfortunate if that my lord just posited,
Yeah.
that the Dubai Court of Appeal says they were right,
Yeah.
there is no jurisdiction in Dubai to review
Yeah.
the jurisdiction of a tribunal sitting in Dubai applying Dubai law. If that is the determination, then of course that would be a very relevant factor for the winding up court at a further hearing of the petition, if adjournment is the way forward, when reconsidering whether Justice Sir David Steele's earlier finding that there was a realistic prospect of success remains a good one or not. It would be a further ingredient to add into the court weighing, as a matter of its discretion, whether it believed that there was a realistic prospect of success in the challenge to the award.
But how would that help you? How would that?
My lord, if the appeal court's against us, it wouldn't help me. It may do absolutely the contrary. But if the appeal court is with us and finds that the dispute is one that is to be determined as to jurisdiction in the courts of Dubai, then we say that you put together the fact that the parties agreed by their contract ultimately that the Dubai courts would be the relevant jurisdiction to review issues as to the jurisdiction of the tribunal that has made the award, and you put alongside that the fact that the courts in the DIFC have already quite properly in our submission said that that is a challenge which has a realistic prospect of success, and the answer for those two ingredients is that the Dubai courts should not, in our respectful submission, be making a winding up order on the basis of the authorities against that backdrop. That's why it's important.
Yeah.
My Lord, I think, indicated that the background is something that my Lord has clearly been able to do pre-reading and be well aware of the factual backdrop. I mean, the only thing I think I would mention in addition is that my Lord will have seen that the challenge before the Dubai Appeal Court was already ongoing at the time the petition was issued. So the petitioners were very well aware that the jurisdictional issue was being pursued in what we say is the proper forum with due expedition by the company. It's not a case of the company stalling. They were getting on with things as quickly as they could, and they have continued to do so in the Dubai Appeal Court since the issue of the petition. That's the only other factor by way of chronology that I think is important for my lord.
In terms of chronology, just a way of update, there is a Court of Cassation and then the Supreme Court.
Thank you.
So, well, with that in mind, then, turning to the first ground of opposition.
Yes.
I don't know whether my lord has a copy of our skeleton
Yes, I
argument
have. I've got it right here.
to hand, my lord. I'm very grateful. What we have sought to do for my lord at paragraph 12 of the skeleton argument, beginning on, sorry, paragraph 11, I'm so sorry, beginning on page 6, is to set out the relevant legal principles that we say apply equally by way of analogy in the DISC jurisdiction when the court is sitting as a winding up court. We say that the principles are the same because essentially the DISC insolvency legislation has adopted the model of the UK Insolvency Act.
Which page is it in your
My lord,
sorry?
page 6 of my...
Page 6 of your...
Page 6. My lord should see the cross-heading legal principles.
Yes, I know.
And start in paragraph 11, where we set them out for my lord. So we say the test is the same, and I'll come in due course to what Justice Sir David Steele said about this on the application of the conjunction as well. And what we have sought to do for my lord is to set out a number of appellate-level statements of principle in relation to what is the test for the winding up court. And we do this against the backdrop of where, at the last hearing, the claimant hasn't even tried to do it today, but at the last hearing, they tried to persuade the court that these authorities do not apply where the petitioning creditor has a judgment test. They said these authorities only applied in the scenario where you have a debt due under a contract and you haven't yet established your claim by way of a judgment of the court.
Yes.
And we'll come to what the judge said about that in a moment. But my lord, maybe if I could just take my lord to just 2 or 3 of the decisions to really identify the principles. I think in relation to the first one at subparagraph 1, I can really just show my lord the quote that's in the skeleton argument, what Justice Chadwick says. He says the relevant question is the issue a genuine triable issue? If it is, then that ought to be resolved by a trial before insolvency process is invoked.
Yeah.
And then the Arena Corporation I was going to take my lord to, and this is where I'm worried that our different tab numbers may be running. Can I give my lord bundle numbers?
Yeah.
Just out of caution. It's bundle number 344, 344. Yes, just give me a moment. Well, of course. My lord, if things have worked, my lord should have a judgment.
The Arena Corporation.
Precisely, indeed. A judgment of the Court of Appeal, the judgment given by Sir Andrew Mollett.
All right, just wait a minute. That's Article 110. Yes, go on.
My lord, just really delving into this for the key legal proposition, this was a case where there had been an assessment by HMRC in relation to taxes owed, and the effect of the statute is it's deemed to be a debt due and owing.
Yes.
In other words, it can only be overcome by way of a successful appeal before the VAT tribunal.
Yes.
And the judge and the Court of Appeal, because the judgment was agreed by the others sitting on the tribunal, addressed the question using the bundle numbers at page 358, addressed the question of principle.
Yes.
Just for my Lord's note, Lord Justice Mance and Lord Justice Carnwath agreed.
Yes.
So it's page 358. I wonder whether, unless my Lord would like, I'm reluctant to read too much.
No, certainly I'll read it.
If perhaps my
my
Lord could just read paragraph 52 to start with, and then I'll make a submission from that.
Yes.
My Lord, I don't want to take my Lord out of my submissions, but I've just been informed, before I forget, the 8th of June was announced by the Dubai Appeal Court at a hearing before the court today.
Thank you. I'm very grateful.
That is the context.
Thank you very much.
So that's where Sir Andrew Morritt introduces the question, and then, my Lord, jumping to the bottom of paragraph 53 after he's looked at what some other judges have said in relation to the test, he says, for my part, I think that the traditional test of bona fide disputed on substantial grounds is in this case, for all practical purposes, synonymous with real as opposed to frivolous. So the question for the winding up court is the dispute more than one which is merely frivolous? If it is, then that is an issue, back to paragraph 52, that should be resolved by the tribunal. And why? Because it's not the function of the winding up court in the exercise of its winding up jurisdiction to determine such disputes.
Yes?
My Lord, that's the key point from that case. I'm reluctant to cite too many authorities for the same proposition, but I think it's just important to see how many different Court of Appeal tribunals have put the test in the same way. So maybe just to look at two more cases together rather than all those cited in the skeleton. Mm-hmm. The next is the Argentum Lex Wealth Management case, using my Lord's internal numbers. It's page 385. Just so my Lord sees, it's a judgment given by Lord Justice Longmore, with whom Lord Justice Ward and Lord Justice Sullivan agree.
Yes.
And the key part to show to my Lord begins on page 390. 390, paragraph. I'm going to take my Lord through paragraphs, the key points in paragraphs 17 through to 22.
Well, I'll read those paragraphs now.
My Lord, most pleasure.
Yes.
So I'm really taking 3 points from the passage that my Lord's just seen. The first is at paragraph 17, where Lord Justice Longmore equated the test with realistic prospect of success. So the same as judicial review or granting permission to appeal. Once you're above that bar, you should be outside the winding up court. And then at paragraph 20, is the key question he asked after looking at the grounds of opposition is, well, were they merely fanciful? And he said, my Lord will have seen in the second sentence of paragraph 20, but for my part I cannot say they are fanciful. So he said there are obvious difficulties in the way there, but obvious difficulties. But he couldn't say they were fanciful. So he didn't think much of the dispute, but he couldn't go as far as to say they were fanciful only. And then at paragraph 22, what's the conclusion in those circumstances? The conclusion is the court, sitting with its winding up hat on, should not then be going further and seeking to resolve the dispute.
Yes.
So, well, that's the decision in the Argentum case. Going back to the skeleton argument, subparagraph 5 is another decision of the English Court of Appeal, the Tannington Legs case.
Yeah.
My Lord, I wasn't going to take, my Lord, to that. Say, we've repeated paragraph 5 at the top of page 8, where again the court sets out in similar terms the test for whether the company's court will look at disputed debts or not. But I was going to take, my Lord, to the next case, at subparagraph 6, the Enter Technologies case, because it's the most recent word of the Court of Appeal on the issue.
Yes.
My Lord, that begins at page 431 of the bundle.
Yes.
My Lord, two very experienced Chancery judges on the panel. The judgments given by Lord Justice Voss, Lord Justice Patton agreeing, and Lord Justice Longbourn, who my Lord saw in the previous case,
yes,
also agreeing.
Yes.
The context is an application to wind up in circumstances where there was an ongoing appeal in the VAT tribunal. My Lord sees that from paragraph 1.
The first decision, which is being appealed to the appeal tribunal, is that a judgment?
My Lord, no, that's the notice given by the revenue of the assessment, which under the statute is treated as if it were a judgment, so it has to be appealed.
Yes, thank you.
And Lord Justice Voss, paragraph 1 in the second sentence, highlights the point for my Lord that's before the Court of Appeal. So, paragraph 1, the second sentence, the point is whether, when there is both, 1, an appeal against the VAT assessment pending in the first tier tribunal, and 2, a winding up petition pending in the company's court, the tax tribunal or the company's court is the appropriate forum to determine whether the petition debt is disputed in good faith on substantial grounds, and then you see the test again, or in other words, whether the appeal has a real as opposed to fanciful or frivolous prospect of success.
Yeah.
So the company's court only gets involved if it can be determined that it's fanciful or frivolous. We'll see that in a moment.
Yes. Yes.
Second point, paragraph 46, page 441.
Yes.
Third sentence, final sentence, my Lord may see the words "of course" at the right-hand side.
Yes.
What the judge says, of course, HMRC had to assume the burden, as it sought to do before the judge and before us, of persuading the court that, in fact, the debts underlying the dispatch assessments were not disputed in good faith on substantial grounds. So the burden is on the petitioner to show that the debts are not subject to a dispute, which is more than merely frivolous.
Yeah.
Now we know that today there's been no real attempt to engage with these authorities or explain why it could be said that our dispute is one which is merely frivolous. Yeah. So, well, they're the key paragraphs from that case. The conclusions, maybe my Lord can just see it, 71 and 72, if my Lord would just read those paragraphs perhaps. Page 444 to 448. 447, I'm so sorry, to 448. Under the subheading conclusion at the bottom of 447.
Yes.
Yes.
So normally even the determination of whether the dispute gets over the relevant threshold is a question for the appellate tribunal, not the winding up court. But if the winding up court could be satisfied the case was exceptional and the dispute was not, did not overcome the merely frivolous hurdle, then the winding up court could go ahead and make the order.
Yeah.
Now, with those authorities in mind, that was really the landscape of the debate before Sir Justice David Steele, only some, I think, 3 weeks ago, maybe 2.5 weeks ago.
Do you have a decision where a judgment of the High Court is the subject of an appeal, leave's been granted, but there's no stay of execution, where a winding up petition was then presented and the court held that the pendency of the appeal meant that it should not grant the petition?
My Lord, what we have is the statements my Lord's seen in the case, equating the realistic prospect of success test. My Lord has statements in textbooks that if an appeal's in train, the winding up court will not usually go and make a winding up order.
Yeah.
And my Lord actually has the benefit of Justice Sir David Steele's judgment on the very issue, because that was the landscape of a 3-hour debate at the end of April. And perhaps I can just take my Lord to what the conclusions were of the judge at that hearing.
Yes, this is the Steele judgment.
Absolutely, because
Can you just tell me where it is?
Of course, my Lord. It's behind. If I can just use the bundle numbers to make sure we're in the same place again.
Yeah.
It's 705, so right towards the back. My Lord should find at 705 the injunction order.
I've got the order. Yeah.
And then if my Lord turns over, my Lord sees the schedule of
There's
reasons.
the schedule of reasons. Right. 2 and 40. Yes, now I have read these, but I ought to have a look at this again. Any particular paragraphs you want to take me to?
My Lord, absolutely. Of course, we submit it. Very important. Of course, my Lord sees what's already been argued and determined before in any event. And there was an extensive skeleton argument trying to run these arguments by the claimant last time. They lost on them. The very point my Lord just asked me about.
Yeah.
They lost that issue.
Yeah.
And my Lord sees that at paragraphs 10 and 11. I don't know whether my Lord could just read those paragraphs.
Yes, certainly. What's the logic of his decision that the injunction should be granted restraining publication until the petition is heard, but no restraint of the petition?
My Lord, the logic we suggest is as follows. It was said by the petitioner at the hearing we shouldn't have our injunction because we were bound to fail. They were bound to get a winding up order because they had the equivalent of a judgment debt as a result of the recognition and enforcement of the award, and therefore the court would be bound to go ahead and make a winding up order. The judge said no, that's the wrong analysis of the authorities. The question for the court is there a dispute which is more than merely fanciful?
Yeah.
That's the question.
Yeah.
And then the judge went on, and we say, I don't know if my Lord just read 12 and 13 as well then. We say that you see, particularly in 13, that when the judge talks about what may change, he actually only countenances the claimants being allowed to come back and advertise the petition and take further steps, if you like, on a petition, because advertisement is necessary ultimately to get a winding up order, in the event that we've lost in Dubai. And that's the game changer. And if we haven't lost in Dubai, then there is the dispute. They can still take enforcement steps, and the judge is very careful to say, look, this is about a winding up order, it's not about enforcement.
I understand all that, but having accepted your side's mission that where there is an appeal that has a real prospect of success, in the sense that it is not frivolous, a winding up order ought not to be made. What is the logic in allowing the winding up petition to go ahead?
My Lord, we would say, with respect, very little.
There isn't any, is there?
And the authorities...
Well, what's the answer to that? Is there any real logic in this part of the decision?
My Lord, well, the short answer to my Lord in relation to this part of the decision is based on the English authorities, which have seen no, particularly the judgment of Lord Justice Longmore, which is an injunction case. The court said if the company gets over the merely frivolous, the merely fanciful, the court then grants the injunction and strikes out the petition. So we actually do say that the judge should have followed the logic through of paragraphs 10 and 11 and struck out the petition back in April. But the judge didn't. The judge has left it open to see what may change and may come up. Nothing's changed. We're still in a position where we have an issue which the Dubai court, the DIFC court has found to be over the realistic prospect of success threshold, in the circumstances where the DIFC court has also found that the relevant question is there a dispute over the realistic prospect threshold? And we say the logical consequence of 1 + 1 being 2 there is that the court should go ahead and dismiss the petition unless things have changed. And things haven't changed, as my Lord knows, because we are at the moment still waiting for the Dubai Court of Appeal to resolve, to rule on the jurisdiction challenge. Now, it may be, and I put it no higher because my Lord has my primary case in relation to what this court should do, but it may be that this court feels that in the overwhelming circumstances of the case, that it's appropriate not to do what the authorities normally say, which is dismiss, but to adjourn. And that is something which is my secondary submission, and something which may be weighing at the back of the judge's mind when the judge didn't follow through, because my Lord will have seen that the judge did note in his judgment that he should take account of the fact that the defendant had in the past run some points which were rather poorer than the jurisdiction one before the courts. We say they're the logical consequence of paragraphs 10 and 11 today. In fact, a conclusion which Mr. Brannigan hasn't even tried to argue against today, or cite any authorities against today, is that the petition must be dismissed on the authorities. We're outside the winding up court, as properly understood jurisdiction.
Well, perhaps the logic is founded on practicality. An adjournment avoids the time and cost involved in issuing or presenting a new petition if the landscape changes. So this petition can be parked and the life breathed back into it.
I appreciate it, and that's why I put it as an alternative case, which has the advantage of enabling the proper forum to resolve the dispute, and if it was thought as a matter of discretion that the court should not do what the court normally does in the winding up jurisdiction if there is a dispute, namely dismiss the petition, if the court, there were some circumstances as to why it shouldn't do that here, then we say the only other alternative available to the court is adjournment, not a winding up order, because a winding up order would be, in our respectful submission, totally wrong on the authorities where there is already concluded to be a dispute which is more than fanciful.
Now, in the area of summary judgment, the court often concludes that there's just enough here to merit a trial. But the cost of the trial, I'm afraid, is the provision of security, which is the practical, the empirical way the common law works. Now, does the court have jurisdiction when it's faced with a winding up petition to say, well, this might just get over the hurdle of not being fanciful, but the position of the judgment creditor is deteriorating qua the judgment debtor every day. And so if there's to be resistance to a winding up order, the cost is the provision of some security. Does that ever happen in the company's court?
My Lord, the short answer is not really. We got into that last time. There are statements of principle saying the court should make a decision one way or another. If there's a dispute, then you're in the wrong jurisdiction, and you should be in your civil proceedings with your freezing injunction, with your request for security, etc. This case is actually slightly different, as my Lord knows, in any event, because there is presently a freezing injunction in place in relation to the claimant's assets. And if it's truly believed that there is some problem in relation to the company's disclosure and conduct in view of that freezing injunction, the proper course for the petitioner is not to try and seek to wind the company up, it's to apply back to the court in relation to the freezing injunction. Now, my
Is there any jurisdiction to appoint a receiver rather than have the rather brutal remedy of a winding up order, as you would put it? The appointment of a receiver to safeguard the assets would not prevent the continuation of an appeal before the mainland courts, but it would allow an officer of the court to report to the court on what's really going on with these assets and to take steps to ring-fence them, wouldn't it?
Well, my Lord, the first thing I would say before, I don't want to misspeak on the power, I'll check that, is that the freezing injunction is the right way to do it here. And maybe just
a bit of a clunker of freezing injunction.
Well, maybe just noting one point in that regard. There was once before a suggestion by the petitioners that there had been misconduct by the company in dealing with its assets, and there had been non-disclosure. Can I just show my Lord what the judge said, the recognition and enforcement application about that allegation?
Yes.
If I can just take my Lord to page 278 of the bundle, we're within the recognition and enforcement judgment now.
Yes.
My Lord, could I, again, rather than reading extensively to my Lord, could I invite my Lord to read paragraph 77, beginning reliance was also placed, to the court's conclusion of paragraph 80 about whether reliance should ever have been so placed?
Yes, certainly.
Yeah.
So my lord sees that the petitioners have been caught out before in suggesting there has been misuse of funds and misdealing of funds. And we say that if there really is any evidence of our failure to comply with the terms of the freezing injunction, the proper course is to apply back to the court. We thoroughly rejected them before when it's been suggested there had been a misuse of funds. The court absolutely rejected and said the allegation should never have been made. My lord, we're talking about real property in particular in Dubai. It's not things that can just be merrily disposed of. It's not that sort of case. There is a freezing injunction in place.
Has it been? How does it work between the two jurisdictions when you have a freezing injunction over assets within the mainland jurisdiction rather than within the DIFC? Do enforcement proceedings have to be taken to give effect to the injunction that's granted within the DIFC?
That is my understanding, and maybe answering also a question posed earlier by my lord. Would the appointment of a liquidator make any difference? We say that's the wrong question because the petitioner was assuming they could have a liquidator without actually addressing the legal test they must overcome to get a liquidator. But even assuming a liquidator is there, as a matter of discretion, we would say that's another thing in favour of an adjournment, because my lord's quite correct that cross-border insolvency, you can't just go into another jurisdiction, put your hand up and say, these are mine. You have to go through the procedures of having your appointment recognised and enforced, and your authority to be the agent of the company in that jurisdiction before you can take any steps. And my lord was quite right to call Mr. Brannigan out on, why on earth is the Dubai court going to do that when there is currently a challenge pending before the Dubai courts in relation to the award which is relied on to found the petition which the liquidator is appointed under. Well, it was absolutely correct to do that. In cross-border insolvency, it doesn't work like that.
But, well, perhaps I could ask Mr. Brannigan, what steps have been taken to enforce the injunction? Not, of course, by contempt proceedings for breach, but to ensure that the order runs in the mainland jurisdiction.
My understanding is none. We have relied upon the fact that if somebody were to breach the freezing injunction, we could bring them before this court and have them committed. And so for that reason, we haven't felt the need to get a similar injunction on the mainland.
I see. But of course, if you wanted a charging order or anything of that sort, then that would have to be done through the mainland court.
The whole point of getting a freezing injunction is to...
Now, I've not looked carefully at the asset disclosure affidavit. But what's the position? Are there secured creditors of the respondent?
Well, absolutely. That's one of the points we make in our evidence and was made in the submissions in relation to whether it really is in the interests of the petitioner to take these sorts of steps, which, if a winding up order was made, we would say the necessary consequence is usually that you get depreciated values for the property held by the company which it's seeking to sell. And in this case, there are banks with security who come in advance of the petitioner, so it's not even in their interests to have a liquidator and depress sale prices in any event. They rank after the secured creditors in the queue in the normal way.
Well, on the basis of the asset disclosure, what is there in this company that's worth anything to?
Don't know until we see what the true assets are. We don't believe.
If you've got you don't believe the asset disclosure.
No. Why would we, in a situation where they've acted in bad faith and where Mr. Justice Steele has looked at what they've said and said elements of it are dishonest?
Well, the answer to that is not a winding up petition against a real prospect of success.
I'm not saying it is. What I'm saying is, you've asked me why we want to wind them up, and the answer is to get hold of the assets. The other thing we don't know, and we can go into great depth, what we do know is that from whenever they began to realise that they'd lost the arbitration, assets began to leave the company in significant numbers. So what we're presuming is a liquidator will look at all of that and may well seek to unwind some of those transactions to get the assets back in.
Anyways, you have the floor at the moment.
My Lord, thank you. And I reject that completely. Of course, the point is at the moment there is a freezing injunction. There is the ordinary course of business exception in the normal way. There has been an attempt before by the petitioner to say there has been a misuse of funds, they were called on that by the court. The court said that allegation should never have been made. If they think there is something wrong with the asset disclosure under the freezing order, if they think the freezing order is not operating properly, the appropriate response is not to seek to wind the company up when, as a matter of jurisdiction of the winding up court, they cannot do so and don't even seek to explain to my lord why they can. The proper approach is to apply in relation to the freezing injunction to further disclosure if they think that is the right course. My lord, we just finished looking at the legal principles. And really, the short point I was going to make is, my lord has seen how Justice Sir David Steele answered the very question my lord posed to me a moment ago. And we rely absolutely on that. And they haven't sought to contend today that was wrong or bring any arguments to bear on that point. The second point is that, well, once one accepts the question is there a real as opposed to frivolous dispute? Again, that's been looked at before and the court has said it's real. The court said it's not frivolous. There is a realistic prospect of success. And as my lord saw there in the judgment, that's hardly surprising because with due respect, and I mean this absolutely with due respect, how can the DIFC court be expected to reach a final view on something which ultimately hangs on the UAE constitution and is a matter of which applying Dubai law for the courts of Dubai? That is the place the dispute should be resolved, and importantly that is in accordance with the agreement of the parties in relation to this contract. That is the forum where the disputes should be finally determined. So we say that when one puts the legal test together with the previous conclusions of the DIFC court, and with the fact that we are pursuing the appeal with all due expedition in the court of the Dubai courts, there is absolutely no reason why the court should do anything other than make an order dismissing the petition today. My lord, we say that's in effect the end of the matter. My lord's concerned with the class remedy of a petition today and whether the petitioner can get through the gateway to access that. And my lord has, in our respect, the clear answer, no. Winding up Hasson, no. There may be other steps they can take. We don't for a moment accept they should succeed in them in relation to, example, the freezing order and steps for enforcement by way of charging order or otherwise over properties. But that's not an application that is before my lord today. The application before my lord is for a winding up order in the face of the principles in the authorities, in the face of the conclusions of the DIFC court, in the face of the conclusion of the DIAC tribunal finding the jurisdictional issue a difficult one, and therefore we say the cards only fall one way. We have all the cards. My lord, we run in our skeleton argument two alternative bases. The first is we're over the threshold of a dispute and that's the end of the matter. My lord will have also seen that there are two different grounds of dispute relied on in our skeleton argument. One is oppression and unfairness, and the other is really the winding up order is the most draconian remedy available, and there are other remedies available here and no proper explanation as to why they're not pursuing them.
So how often does an English court refuse a petition for wind up on the basis that there are other remedies available?
It's something that can be considered as a matter of discretion because of the word may.
Yes, but how often in practice? I know there are cases that say this petition is being advanced for collateral motives.
My lord, I was going to say it's normally combined with a finding of, well, hang on, there are other ways they could do this, and that is going to help us with our inference that they are doing this for a collateral purpose. And that's really the way we've put it actually in the skeleton.
I think you'd have to, because where let's say that there are assets in a company which are not the subject of prior securities, which are on a reasonable appraisal adequate to discharge the debt, but the company's refusing to make any kind of offer to discharge. If you sought to wind up the company, would a court really say, well, we're not going to grant the petition because you can get charging orders and so on?
Can I just one question? My Lord, I assume has descended into a factual premise where there is no dispute, which is...
That's right. No dispute as to the debt, the validity of the debt.
Which is why we put it as a tail-end ground. It only becomes relevant if we lose on the key question of dispute. Well, my Lord, the answer to that is, really taking my Lord's example, if there was no one else ahead in the queue, and if the only suggestion was, well, you should go and do something else because you could do something else rather than wind up the company, that would be a very hard case to win as a matter of discretion before the winding up court. And I absolutely appreciate what my Lord says there. The way we put it slightly, let's now assume one interposes a secured creditor who ranks above in the queue, and there's no obvious means of recovery for the creditor within the winding up. And let's also put alongside that there is pending litigation between the parties which may be stifled or killed if a winding up order was made so as to give rise to a collateral purpose inference. That's when the court, as a matter of discretion, may say no. And we cite an Irish case, Good Concrete, where that very thing happened. The court said, well, hang on, you haven't given any evidence that you can get your hands on assets in a winding up, and you are very hopeful that if the winding up order is made, the proceedings between you will disappear because you hope that a liquidator won't continue them. And in that case, the court said, well, I'm not going to wind up. What I will do is adjourn for a period of time or, say, dismiss petition. But, my Lord, I accept, and that's the way we put it. You have to be in that sort of arena.
Yes, thank you.
And the other one, which really, I think, piggybacks in many ways into the dispute, which is, as a freestanding discretionary reason here, there is also the interrelationship between the two jurisdictions, which is a matter of some importance. And we say that goes really hand in hand to emphasise if you get over the frivolous threshold, there's only one way the discretion can be exercised on the authorities then. Even if my Lord is not certain on the frivolous threshold, we say there's only...
comity comes into play.
Precisely. And the comity comes into play there by dismissing and waiting to see what Dubai says before a winding up order is made, which would irretrievably damage the company, or alternatively to adjourn. So the ring is held in relation to those winding up proceedings in this jurisdiction as a matter of comity until the Dubai courts get to determine the root of the award on which the petition is founded.
Yes.
My Lord, if I could just check, I think that is probably all I wanted to say, unless my Lord had any questions. My Lord, I think I've dealt with all the points noted during Mr. Brannigan's submissions, save really to emphasise the fundamental error in the target.
You're seeking three alternative outcomes. Dismissal of the petition.
On the basis of the authorities, my Lord, yes.
A stay.
My Lord, I haven't addressed that. I'm sorry, I haven't. That is something which I haven't made submissions on at the moment. I've addressed the petition.
Right.
I hope, understandably, in that the stay doesn't become greatly relevant in relation to the petition, at least, if I succeed on dismiss as a matter of the relevant standard or adjourn as a matter of discretion. Stay then doesn't need to come into it.
Yes. There's not much difference between adjournment and a stay, is there?
Well, apart from the fact that the court can, of course, because the remedy is to may be wound up if the jurisdiction is established, my Lord's exercising a discretion which is not the same as a stay discretion. My Lord can, and the English courts do as a matter of regular occurrence, adjourn winding up periods, petitions for a period to see what happens in the intervening period.
But what does a stay achieve that an adjournment?
In relation to the petition, nothing at all, and that's why I haven't addressed my lord on it in any detail.
Well, are you seeking a stay of something else other than the petition?
Well, there's no attempt to enforce by way of charging orders or otherwise over the properties, certainly before my lord today. So I'm not sure I am formally seeking a stay in that respect, but can I just take instructions? My lord, no, today is concerned with the petition, and my lord has my submissions on the petition.
Dismissal or adjournment?
My lord, absolutely.
Yeah.
There's one. I'm so sorry. There is one other matter which my lord asked about during Mr. Brannigan's submissions. My lord posited the scenario. What if, in the DIFC, there is a judgment, there is an application for permission to appeal, that is refused on paper, that's refused by another judge at the equivalent of an English oral hearing?
Yeah.
Is that the end of the matter?
Yeah.
Not quite in Dubai, actually. There is an additional rule, it's RDC 44.179, which in exceptional circumstances you can reopen a final appeal. Something unknown to us under the English CPR, but there is a provision in the RDC rules which allows you to do so. We can get a copy of that for my lord if it would assist.
What did that subsequent evidence was?
And my lord, it expressly includes on the wording of the rule a case in which there has been a refusal of permission as well as the end result in relation to an appeal.
Almost certainly it would have to depend on the fresh evidence, the emergence of something.
Or perhaps the comity issue between the courts in circumstances
that would be prevailing at the time that the original decision was taken. There would be some kind of change of landscape.
My lord, yes, I mean, it would in the sense that now, let's maybe, I don't want to make too many assumptions, but let's assume that when the court said no in relation to permission to appeal, or when the court said no in relation to, well, you can't have any adjournment of the enforcement application, at that stage it didn't know that the appeal court in Dubai was going to rule within a very short period of time. Justice David Steele, of course, my lord will have seen, thought that things would take a lot longer in Dubai than in fact they did in relation to the first instance decision, and they're anticipated to in relation to the appeal court. That may be the sort of change of facts.
I see.
And then the comity point comes front and centre of the debate.
Yeah.
But obviously that's, again, I'm really putting those points just to answer my lord's question.
Yes,
Today is, has your petitioner established its entitlement to the class remedy, yes or no? If it has, should it have the order, or should there be an adjournment pending what happens in Dubai? They're the two key questions for my lord.
Thank you very much. Thank you very much. Yes, reply.
So it'd be useful to have some clarification, because how the stay application has just been described to you isn't what the stay application in fact is. The stay application that has been made, and which has been listened to hearing in front of you today, isn't just a stay in relation to a petition. It is expressly an application for a stay of the whole thing, so as to prevent us from using any other method of enforcement as well.
I hope I made it clear when I said that my lord's hearing the petition today. There is no application for a charging order or anything else of that nature today, and therefore
So
there's no advancement of that part today.
Yes.
Maybe that I've not asked you to make a charging order today, but they have made an application which you have been asked to deal
Well,
with
those are not moving a stay application of any form of execution.
Well, I would ask them, whenever you take out your judgment, that's reflected in their application dismissed if it's not been moved today. But that is the application. The reason I say that, just to be clear, is I don't want next week a letter to go into the DIFC registry saying, by the way, we haven't in fact dealt with some of our stay application, and can we please now deal with it? So that's why I flag it.
Yeah.
So leave another point is that it seems to me that there are two or three things I could usefully say to you. The first is this. Proposed what you will have anticipated from my submission, we say is the key question, which is to my learned friend right at the start, which is in a situation where Mr. Justice Steele seems to have expressly dealt with this issue of comity, as my learned friend describes it, and intersection, as I have described it, against the background of everybody understanding that these are the points that's going to be made in front of the Divine Court. What does this jurisdiction do about that in terms of recognising judgment? You ask my learned friend the question, well, doesn't this mean that this has been decided long before their application for an injunction was made? It's a matter for your lordship whether or not you think you got a satisfactory answer to that. You'll understand my submission is I don't think you even got an answer to it, let alone a satisfactory answer. And it is the key question for today, really, because their whole point is, because there is this stuff going on in another jurisdiction, that in and of itself is sufficient to constitute something like an appeal of this court's judgment in this jurisdiction. And one only has to state that to say that that's just obviously wrong. The fact that they have proceedings on foot in another jurisdiction does not help them in a situation where this court has made a decision as to how those proceedings should be dealt with here. You've never had an answer from a learned friend to that simple point.
Well, I don't know if I need to respond. I think I did answer that very point.
Carry on.
The cases which he has gone so much to cite don't help him in relation to that. Because what those cases demonstrate is that if within a particular jurisdiction you have an appeal on, so you can't say that the judgment is final, well, that can be a reason why you can say that the court in that jurisdiction can say that this isn't a final judgment in the sense of not being the subject of a bona fide, non-fanciful attack upon it, or the debt not being disputed on non-fanciful grounds. But that isn't here. Now, we have the point which your lordship has. You're going to have a look at what is said in the appeal within this jurisdiction. I completely get and accept that. And we hope that you will decide that as a fanciful appeal on anybody's basis. But in relation to the appeal out of the jurisdiction, I say you've had no proper answer to the point that this court has looked at and decided what happens in terms to those parallel proceedings. And there is no good reason to disturb it.
Well, what's been submitted is that Justice Steele made the conventional order that the award should be enforced as if it were a judgment made by the court.
Yes.
And therefore, the panoply of enforcement procedures is available.
Yes.
What's said against you is he has not said that those enforcement procedures should operate in some restricted way, in some way that wouldn't otherwise be the case.
He hasn't said anything about one way or another.
No. Your contention really comes to this, that by deciding that if security is not put up, this judgment can be enforced, that's an end of any consideration as to what may happen in the mainland courts. And that, in a sense, is a question of construing the order that's been made against the relevant background.
Yes.
Isn't it? It really, your contention is that Justice Steele's order precludes any of this that we've heard.
Yes.
And I have to decide whether that's right, or whether instead the effect of the order is you may now come to the court and pray in a different means of execution. And in doing so, you must deal with the relevant principles that apply to those means of execution.
Well, it's halfway in between, because I was with you up until your lordship said the last couple of sentences for this reason. I do come to you now and pray, and say you must now consider what means of execution we have, and you're not bound to give us the class right of making property insolvent. But the point is that whenever you're considering the judgment before you, and you're asking, is that judgment disputed on bona fide grounds? What you shouldn't do, by reason of the previous order, is take into account at that stage that they may have all these other grounds that they're running in the Dubai courts. So I'm not saying you are shut out from asking the question. I am saying that the question is the answer to the question is informed by the fact that at the point the judgment was considered to start with, Mr. Justice Steele looked at that and said, in essence, to the other side, you have a choice. If you want not there to be a judgment here, which will then push you down the road of having to appeal it, if you wish to appeal it in this jurisdiction, you must do this. If you don't, there'll be a judgment, and it will then be a judgment of this court, without an asterisk beside it, saying it's a judgment but not really. It is a judgment of this court. That judgment of this court is not the subject of a bona fide dispute within this jurisdiction. The best they have is this appeal from Judge Omar's decision, which I can now see, and I should have thought before, and you got to look at. But that judgment of this court is not the subject of an appeal elsewhere. That's the key point, and if I can encapsulate my point in one sentence as that judgment is not the subject of an appeal in another jurisdiction.
Well, was this argument run when the inter partes hearing occurs, as to whether there should be an injunction restraining presentation of the petition?
My understanding was I wasn't available for that, so my learned friend was.
My Lord, yes, the skeleton's in the bundle if my Lord wants to see it was run in detail. And the judge didn't think very much of the point, and certainly didn't think that the fact that he had granted recognition and enforcement led to these bizarre consequences on the winding up petition.
Okay. Thank you very much.
Would you like me to continue?
Yes.
Thank you. It was wrong when we have this judgment. I agree, and with great respect to Mr. Justice Steele, the judgment's a little difficult to follow in terms of where he got to. What we do know, though, is that he didn't accept my learned friend's proposition that because of the points that he is making, this shouldn't go ahead. He clearly thought that there was room for you, my Lord, to take the view that there should be a winding up, and we know
I'm
that.
not sure how grateful I am to you.
Well, quite. Well, you and me both in a way. But that's what he thought. And I don't think either side is saying that you are bound one way or another here. If they are, I've misunderstood my learned friend. If he is saying you now cannot, by definition, decide this because of something that Justice Steele said, we say that's obviously wrong with respect, at least because he left it to you to decide. But even if I'm wrong about that, the problem with that is the antecedent point, that if we're going to rely on decisions that Mr. Justice Steele has made, we should rely on the first one first in terms of this. And we have to take that on its face in terms of what it means. And we end up in a position, and just to pull this together and then move on to just one, I suppose, final point. We end up in this position. It's a slightly odd position. In this jurisdiction, the only extant dispute to the judgment before the court is the one that you're going to have to look at in relation to the application for reconsideration of Judge Omar's decision. It cannot be right that proceedings in another jurisdiction can be taken to be some form of disputing of the proceedings in this jurisdiction. That is not giving proper respect to what this court has done, and not giving proper respect to the jurisdiction of this zone or jurisdiction. And it's not as if it is a lack of comity for this jurisdiction to guard jealously the four corners of its jurisdiction. Because the DIFC is the product of the national laws expressly setting up this jurisdiction for a particular purpose to do particular things, and which in this case both parties have submitted to, particularly the other side have submitted to, by registering the company here. And we come back to the point which I say you haven't had a proper answer to, that if this works, if going to the Dubai court and then if need be up to the Court of Cassation, if need be the Supreme Court, works so as to frustrate the ability to wind up a company, this court will never, ever in this jurisdiction issue winding up orders. That's the reality of it, or at least will do so in so few a set of occasions as to make the winding up provisions virtually useless.
Well, it may have a... That may be true where the thing is founded on an arbitration, the seat of which is the mainland jurisdiction. But what wider implication it may have, I'm not sure. But you need, I mean, it's not essential for your argument to spell that out in any further detail.
Two more points there.
Yeah.
One, and this point only goes so far, but it's a relevant point, and it's this. At least a large part of the cases that my learned friend have referred you to are reliant upon the consideration that within the same jurisdiction in the United Kingdom, where the cases come from, different elements of the court do different things. So the company court you see in the case is saying we shouldn't be the party who decides this, if need be a VAT. The Court of Appeal should decide that if there's an appeal to the Court of Appeal, or the VAT tribunal should decide it if it's being considered there. That doesn't translate very well, if I may say, into the DIFC jurisdiction, where you as a judge in the DIFC are being asked to apply the full panoply of functions available to a court in the DIFC as a single judge without the same splitting out. That only goes so far, but it does mean that it is a little bit artificial to say, no, the only thing before you is to decide this, and you have to be very careful. That brings me to my last point, which is the point about security, because there is a way through this.
Yeah.
And the way through this is the way we proposed on the 28th of April 2016, a couple of weeks ago.
Yes.
Which is at page 722 of the bundle. And what we propose, it's a rather long letter, which is obviously written much more for the eyes of the court than it is the eyes of the other side, as you would expect such things. And you may have had a chance to look at this before.
I haven't.
Well,
I must confess.
It is probably worth looking at very quickly, but then pausing to look at a little more closely our proposal for dealing with this.
Yes. Do you want me to do that now?
Please, if you
Yes,
wouldn't mind, my lord.
yes.
It is the final substantive paragraph on page 724 is the kicker to it.
Yes.
So we haven't had an answer to this yet, or even a courtesy, I think, of an acknowledgement that we sent it. But that is at least one way through here. Clearly the court does have jurisdiction if it takes the view that there should be an enforcement order but is concerned about comity. Sorry, there should be a winding up petition. So the company should be wound up, save that it wishes to exercise its discretion in the way set out here.
Yeah.
And I don't actually understand my learned friend to suggest you don't have that jurisdiction, but you clearly do. There is nothing in the rules to suggest that you don't, and you clearly do. It has the benefit of a number of things. It has the benefit of being something that the other side have been in notice of and have had a chance to deal with since the 28th of April, so for a couple of weeks, but have studiously avoided, it appears, doing so to the extent that they haven't dealt with it even today. It has the benefit of being entirely consistent with what Mr. Justice Steele did previously. And you have the benefit of knowing, from the documents I've shown you earlier, that there does appear to be some assets, at least in the background, from shareholders, because as you know, you have been told that although there was only 14 million dirhams in the bank accounts, whenever we froze the bank accounts, some 25 million dirhams have passed through it. We have asked, from whence did those funds come from? And answer, have we none. And all the benefit of that is this. Every time that we have pointed out, and it's reflected in Mr. Justice's judgment previously, every time we have pointed out that a large part of the other side's case in the DIFC is we have very significant and important shareholders. Just one of the points they made as to why there shouldn't be a freezing injunction. And we have pointed out, well then, your shareholders can be the people who take the risk of you not paying up rather than us. It hasn't been disputed that they have these shareholders. It hasn't been disputed that they have the assets available to them to give security, not from within the company, but from within the backers of the company. They, as you know, they appealed Mr. Justice's decision on this, and that appeal didn't even get to the getting permission to appeal stage. So it has not only a decision made by Mr. Justice Steele, but has been approved by Mr. Justice Oger. And if you, my Lord, wish to navigate your way through it in a way that works, that is a proposal that we made a couple of weeks ago, which the other side, they tell us, would be content as not the first option, but a second option for our application to be adjourned. We say that we are equally content, if need be, for our application to be adjourned on the right terms.
Yes. Does the mainland court have a power to require security before it will allow an appeal to go forward?
I don't believe so, no. I can't say for absolute certain, because the mainland court, in my experience, I don't pretend I'm a mainland Dubai practitioner, but I have experience of all of the jurisdiction. I've never seen it do that, but I've equally seen the mainland courts do things nobody can put the finger on and say there's the jurisdiction for that.
Did your side apply for security?
No, I don't believe we did. We took the view that all that would do would be if the order of security would be another appeal, then that would be appeal and then it would go up to the Court of Cassation. I think the view we have taken is that we would prefer the process in the Dubai courts
To be got on with.
And with as few avenues for cul-de-sacs as humanly possible.
All right. Well, thank you very much.
I would point to the new points, in particular in relation to security.
Well, it's not a new point, my Lord. It was made weeks ago, and it's in my skeleton.
Well, I haven't been addressed on it. Just very briefly. Yeah.
My Lord, thank you, I'm best obliged. The first point is there's nothing in the insolvency law or the insolvency regulations which confers a power expressly on the court.
Yeah.
The second thing is, as I said earlier, the practice and procedure of the English courts, it is not. It's do you pass the dispute hurdle? If you do, petition dismissed. If you don't, the court's going to go on and make a winding up order unless there are compelling reasons not to. And my Lord, the evidence has always been clearly that the company cannot afford to post security in this amount. That's consistent with the asset disclosure, so we say it would wrongly...
Yes, but there's a little bit of law on security for costs where funding might be obtained from
My Lord, absolutely in the context of appeals, but we say it shouldn't be translated into the realm of a petition where there is a draconian consequence of a winding up order, and in particular in circumstances where, as a matter of law, if you exceed the relevant hurdle, the result is dismissal, because you're not then engaging the winding up jurisdiction properly. I can't answer my Lord's question on whether the Dubai courts have a power to ask for security. Maybe just one final point, just for my Lord's reference. My Lord asked if the points were run in front of Justice Sir David Steele, i.e. the points on it being a judgment, there can be no proper appeal. I think Mr Brannigan very fairly accepted yes. I was just going to give my Lord the bundle reference.
Oh,
so
I
my
would
Lord
like the bundle reference, please.
It's page 480 to 483.
480 to 483.
Paragraphs 27 through 41.
How long did this hearing last?
Almost 3 hours. And the key point, my Lord, was the recognition enforcement is about whether you're through the gateway under Article 44.